Okay. Hi, everybody. Welcome. My name is Michael Waterstone. I have the honor of being the Dean of UCLA School of Law. So it's my pleasure. First of all, can everybody hear me okay? Folks in the back, great. It's my pleasure to welcome you to the 2026 Melville B. Nimmer Memorial Lecture with Erwin Chemerinsky. For those of you joining us remotely by electronic feed, welcome. Thank you for tuning in. Before we continue, I want to acknowledge that UCLA law sits on the traditional, ancestral, and unceded territory of the Gabrielina Tongva peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. So the Nimmer Lecture is one of our great traditions here at UCLA Law School. We've been doing it for over 30 years. Mel was a legend. He was a colleague here from 1962 to 1985 and the preeminent copyright scholar of his day. His success in the 1971 Supreme Court case of Cohen versus California remains a landmark in free speech and First Amendment law. And everyone knows his signature work, Nimmer on Copyright, the field's go-to treatise. His presence made us one of the leading law schools in intellectual property, and that built the foundation for the success of our current Zifrin Institute for Media, Entertainment, Technology, and Sports Law, which is hosting tonight's lecture and consistently ranks as the leading entertainment law program. Thank you so much to the Nimmer family for continuing the Nimmer tradition. Mel's son, David, is our longtime colleague here at UCLA Law. So I want to thank also the faculty members of the Nimmer Lecture Committee for their work in making this terrific and important event possible. I also want to thank Cindy, where's Cindy, for all of your work in Zifrin, as well as Harley and her team. It really takes a village to pull us together for an event like this. So our speaker today is Erwin Chemerinsky. Now, Erwin is one of those rare people who probably doesn't need an introduction, but I'm going to give one anyway, although I promise mine will probably be different from other introductions you've heard of Erwin. The part that you've heard before, Erwin is one of the most respected and celebrated legal scholars, leaders, and administrators anywhere, and he's currently serving as Dean and Jesse H. Chopper Distinguished Professor of Law at UC Berkeley School of Law. Okay, now for the part that's fun for me. Because I don't think I've gotten to introduce Erwin before here, since I've been Dean at UCLA School of Law. So this will involve me telling you a little bit part of my own backstory. So in between graduating college here and going to law school, I taught elementary school for a year. And I actually worked at two schools. One of the schools I worked at was Emmanuel Day School, a Jewish day school in Beverly Hills. So part of what I did, I wasn't a real teacher, I didn't have a credential, so they were kind of finding things for me to do. One of the things I did that I enjoyed very much was starting a flag football team for the middle school. So they were 6th graders through 8th graders. And we were terrible. Like, we were very, very, very bad at flag football, and nothing I could do would make us any better, but at least we had a team. And we were so bad that no other team, Jewish or otherwise, would really play us because it just wasn't fun for anybody else. So my cousin was the head of school at Heschel Day School in the San Fernando Valley. So because it was my cousin, I convinced them to play us. So we took the bus out to Heschel Day School in the San Fernando Valley, where Emmanuel Day School lost to Heschel Day School something like 75-0. And again, the only reason we didn't lose worse is my cousin, who was also the coach on the other team, was not running up the score on us. So I'm super not happy that we're losing this badly. And my mom and dad, my late mom, came to watch me, her son, coach against my cousin, her nephew. And while on the sidelines, she noticed someone who was quite prominent at the time because he was doing legal commentary on the O.J. Simpson case, Professor Erwin Chemerinsky from USC School of Law at that point. So my mom, being a good Jew, and Erwin, was there watching his son Adam No, it was Jeff. Jeff was a 8th grader on the flag football team. So my mom, being a good Jewish mom and knowing that I was interested in going to law school, immediately cornered Erwin during the entire game. Erwin was probably just trying to watch his son lose 75-0, but my mom finds him and says, "That's my son. He's so brilliant. He's going to go to law school. Will you help him?" So after the game, Erwin, who we all know, the nicest, most brilliant person, comes up to me and says, "Hi, my name's Erwin Chemerinsky. I'm Jeff's father. Your mom says you might want to go to law school. If I can ever be helpful, I'd be happy to." To which my response was, "Dude, get off my field. We just lost. I don't want to talk about law school." So I have the distinction of probably being the person who was most rude to Erwin when they met him. Fortunately, we wound up getting to know each other that year. We coached mock trial together for that middle school. I can assure you our mock trial team was far better than our football team. But so basically, I've known Erwin for now, I think, over 30 years, since I was 22 years old. And at every stage of my life, Erwin has been a friend. Erwin has been a mentor. Erwin has been someone I could call with any question, big or small. As I was trying to become a faculty member and an academic, Erwin was my role model. When I thought about becoming a dean, Erwin was my role model. And one of the really fun things for me now is that we are colleague deans, really, in the University of California system. So that has been kind of a whole new level of our relationship. I think there are a lot of nice people in the world, and there are a lot of smart people in the world. Erwin is the intersection of the nicest and smartest person I've ever met, and I don't say that lightly. So we are all excited to hear from him tonight. Erwin's lecture is titled, "When is a Constitutional Right Infringed? Incidental Burdens in the First Amendment." So, Erwin, we are truly honored that you are here to deliver this year's Nimmer lecture. Please join me in welcoming Erwin Chemerinsky.
Wow. Michael, thank you so much for that incredibly kind introduction. Thank you for the warm welcome. I have to also then tell a story about Michael and our experience. Not only did we coach mock trial together, but we taught public speaking to 8th graders. I've been teaching for 46 years now. The hardest teaching I've ever done in my life was trying to teach public speaking to 8th graders. In the middle of that semester, I went to the then associate dean at USC and said, "I have somebody we have to hire on our faculty. He is going to be a real superstar." And the associate dean said, "Who is this?" I said, "The only catch is he hasn't gone to law school yet. But I think we should hire him now and snap him up as if it was a first-round draft choice." And of course, it was Michael Waterstone. And I so cherish our friendship and our opportunity to work together. Getting the opportunity to do the Nimmer lecture is tremendously special to me. Mel Nimmer was truly one of the greats, not just in UCLA Law School, not just in the field of copyright and the First Amendment, but in all of legal academia. And I was looking at those who have done the Nimmer lecture since it started, and being invited here for it really feels like being chosen for a Hall of Fame. This semester, I'm teaching constitutional law, and I've just gotten to the part of the course where we talk about individual liberties. And I always begin this by talking to my students about how all cases under the Constitution involving individual rights, whatever the liberty involved, involve one or more of 4 questions. One is there a constitutional right? A second is, has that right been infringed? Third, if so, what's the appropriate level of scrutiny to use for that? Is it rational basis? Is it intermediate scrutiny? Is it strict scrutiny? And fourth and final, is the level of scrutiny met? Constitutional theory for the last 60 years has been preoccupied with the first question. Is there a constitutional right? The debate over originalism and non-originalism is very much about that question, whether there's a constitutional right. I think it was fueled by Roe versus Wade and the attempt by some to argue that there shouldn't be a constitutional right that's not in the text or part of the original meaning, and others defending the appropriateness of the court protecting rights, even if they're unenumerated. What I want to suggest to you tonight is that the second question, whether there's an infringement, is enormously important, but has received far less attention from the court, or for that matter, from scholars. Now, obviously, if the government is prohibiting the exercise of a right and imposing criminal penalties, for that matter, civil liability for the infringement of the right, there's no problem. We could go on with the other questions. But there are so many instances where the government is burdening the exercise of the right, but not prohibiting its exercise. And the question I want to focus on tonight is, when is the burdening of a right deemed an infringement, so the government has to meet the requisite level of scrutiny? Let me start with some examples outside of the First Amendment, so you can see what I mean in a more concrete sense of when is a burden an infringement. As you may know, the Supreme Court has said that the right to marry is a fundamental right. What if the government requires that people pay a filing fee in order to be able to obtain a divorce? Is that an infringement of the right to marry? It's not prohibiting anyone from getting married. It's not even directly charging people for getting married. It's more indirect. And yet the United States Supreme Court, I think rightly, in Bodie versus Connecticut said that charging a filing fee in this circumstance does violate the right to marry. The court did this even though in many other contexts it said filing fees in order to have access to the court don't violate the Constitution. Or take another right that's clearly established, the right to procreate. At least in Skinner versus Oklahoma in 1942, the Supreme Court has said that the right to procreate is a fundamental right. Well, many states have policies that if somebody who's on welfare with a child has a second child, there's an increase in welfare benefits. But if they have a third, additional child beyond that, there's no increase in welfare benefits. It's certainly a disincentive to procreate. Is it a violation of the right to procreate? The United States Supreme Court in 1970, in Dandridge versus Williams, said it's not a violation of the constitutional right, even though it's a burden. Or think of abortion. During the time that Roe versus Wade was the law, countless issues came up as to what kind of state regulations should be deemed a burden that was such this magnitude to be an infringement. Examples. If the government pays for childbirth through its Medicaid program or its public hospital, but doesn't pay for abortion, is that an infringement of the right to abortion? The Supreme Court said no. What about requirements for spousal consent or notification, or parental consent or notification for abortion? Are those an infringement of the right? What about targeted restriction of abortion providers, requiring that, say, a doctor performing an abortion have admitting privileges within 25 miles of a hospital? Is that an infringement of the right? Now, of course, all of those cases become irrelevant after Roe versus Wade is overruled and Dobbs versus Jacksonville Health Center. But they were all about the question I'm focusing on tonight. When is a burden an infringement so that the government has to meet strict scrutiny? Because this is the Nimmer lecture, I want to focus primarily on freedom of speech. In addition to Mel Nimmer's classic work on copyright, he also wrote a major treatise that is important to this day with regard to freedom of speech. Well, again, let me give you some examples so you can see what I'm talking about tonight. There's an issue at Berkeley Law and on the Berkeley campus, I imagine here at UCLA, if a student group or a center invites a controversial speaker and there's substantial security costs, can the law school, the university, require that the student group, the center, bear those security costs? Is that requirement an infringement of speech? It's not prohibiting anybody from speaking. It's trying to allocate costs. Or take another example. There are so many laws in a variety of different contexts that require disclosure. I'll give an example of an earlier case. State adopts a law that says, in order to be a public school teacher in the state, you need to disclose all the organizations that you're a member of. Doesn't prohibit anybody from being a teacher. Doesn't impose limitations on who can be a teacher. It's disclosure. Is that an infringement? The Supreme Court in Shelton versus Tucker said yes. Or to take an example from last weekend's news. The chair of the Federal Communication Commission, Brandon Carr, said that television and broadcast stations that do not, in his perception, fairly cover the war in Iran face losing their license. He says broadcast stations have to broadcast in the public interest, and to not cover the war fairly could cause them to lose their license. At this point, thankfully, no license revocation procedures have been brought against any station. But is the mere threat of that enough to be an infringement so one would go on with other analysis and could declare his action unconstitutional? I hope these examples give you a sense of what I want to talk about tonight. What I want to suggest to you as my thesis is that the Supreme Court's approach to this is terribly unsatisfying and unhelpful. What the Supreme Court does is draw a distinction between, quote, an incidental burden that's not an infringement and a direct and substantial burden that is an infringement. This is decisive in so many cases. If the Supreme Court says it's just an incidental burden, the government wins. And if it's direct and substantial burden, and the court uses heightened scrutiny, the government's likely to lose. But I believe that this distinction between incidental burden and direct and substantial burden as drawn by the Supreme Court is an empty one. It's a conclusion that the court gives so as to justify where it wants to come out, but it's without any reasoning. The court's never defined what it means by incidental burden, has never given criteria to determine when it becomes a direct and substantial burden. And my argument tonight is that this is quite undesirable for many reasons, including it's led to underprotection of speech. And I think this is an issue that's going to come up with increasing frequency in the years ahead. So tonight I want to make 4 points. First, I want to argue to you that the issue that I'm talking about of what is an infringement is ubiquitous throughout constitutional law and crucial with regard to the First Amendment. Second, I want to say that what the court has done to deal with this is draw the distinction that I mentioned a moment ago between the incidental burden and the direct and substantial burden. And then third, I want to explain why I said that this is an empty distinction, how the court has failed to define incidental burden, and the court has been very inconsistent with regard to whatever test that it's using. And I, as I said, want to argue to you that for many reasons this is quite harmful. And then the final part of my remarks, I want to sketch out for you an alternative, a set of criteria that might be used to determine when there's an infringement to go forward with analysis. Now I want to acknowledge at the outset that often the definition of the right and the question of whether there's an infringement are interrelated. And sometimes when the court's saying there's not a right, what it's really saying is it hasn't been infringed. And often when it's saying it's not infringed, they're really saying it's not a right. And I recognize that in a relationship. But what I want to focus on is think of all of the instances where the courts have clearly said there is a constitutional right. And then the question is the government burdening of it an infringement so the government has to meet the level of scrutiny? So with that in mind, let me start with my first point. And I here just want to do a quick survey of many areas of constitutional law to help justify why I'm talking about this with you tonight, why the question of what is an infringement is so important. Let me give examples from many areas of constitutional law. I started with the example of the right to marry. In fact, that's the material I was covering this morning in my constitutional law class. And this morning I talked about a case, Zablocki versus Redhouse. It involved a Wisconsin law that said that if a person wanted a marriage license and they had minor children not in their custody, they would have to prove that all of their child support payments were up to date. The question is, does that violate the right to marry? Wisconsin certainly said that it had a compelling interest in making sure that minor children in the state were adequately provided for. The Supreme Court declared this unconstitutional. The Supreme Court said, using the language that I quoted earlier, and this is the case that you might say the language came from, that there was a direct and substantial burdening of the right to marry. The court conceded Wisconsin's compelling interest, but said Wisconsin had other ways that are less restrictive of the right to be able to make sure that the children were adequately provided for. Or take an example from a different area of constitutional law, the right to vote. There are many instances in which the Supreme Court has dismissed challenges with regard to the electoral process just by saying it's an incidental burden. Again, because I want to give examples, take Timmons versus Twin Cities. Minnesota adopted a law that said that somebody couldn't be a candidate on the ballot for more than one political party. It was trying to prevent so-called fusion parties. Challenge gets brought to this and argues that this violates the right of candidates, violates of the political parties to choose who's going to run for them. It violates rights of voters. But the Supreme Court rejected the challenge, saying, this is just an incidental burden. But you can ask, as I am, what makes this incidental? By what criteria has the court come to that conclusion? And it's not just in the area of individual rights that the Supreme Court uses this language of incidental burden. Perhaps in your constitutional law classes, you've talked about the Dormant Commerce Clause, the principle that states can't put an undue burden on interstate commerce. There are many cases there that use the same language of incidental burdens. There was a case, Minnesota versus Cloverleaf. Minnesota adopted a law that said that all dairy products had to be sold in recyclable containers. They had to be sold in basically paper containers. So you had to buy your milk in a paper cardboard container. You couldn't have a plastic container, and so on. Why did Minnesota adopt this? Well, Minnesota has a large paper and pulp industry and doesn't have a plastics industry. It was very much protectionist in the sense that the purpose was to help the local industry. The Supreme Court upheld this, and the Supreme Court said, and I quote, this was just an incidental burden on interstate commerce. Of course, that's a conclusion. There's no explanation for the court, no consideration of the fact that it really was all about helping Minnesota industries at the expense of other industries. As I said to you, I want to focus primarily on the First Amendment tonight. But let me show you as to several different provisions of the First Amendment. The court uses the same language with regard to incidental burden, or what's a direct and substantial burden on the other hand. One of the important free exercise cases, one of the early free exercise cases, was Sherbert versus Werner in 1963. A woman in South Carolina quit her job rather than work on her Saturday Sabbath. She was a Seventh-day Adventist. The state of South Carolina had a policy that if you voluntarily quit work, you weren't eligible for unemployment benefits. She sued and said that the denial of unemployment benefits violated her free exercise of religion. And of course, the state was not prohibiting her from practicing religion. The state was not requiring her to work on her Sabbath. It was just the state said, you quit your job, you can't get benefits. What's interesting here is the Supreme Court said, and I quote, that this was an incidental burden on her religion, but nonetheless used strict scrutiny and declared the South Carolina law unconstitutional as applied to her. This is one of the rare instances where the court uses the words incidental burden, but nonetheless finds an infringement, triggers strict scrutiny, and declares it unconstitutional. Compare that to another case, Bowen versus Roy. This involved individuals who said that having to have a Social Security number violated their religion. They said in their religion, having to have something like a Social Security number robbed their soul and their identity, and it was a violation of free exercise of religion. Now I could imagine the Supreme Court saying, yes, it's an infringement of your religion, but there's a compelling interest in making sure that people have Social Security numbers because we need it in terms of employment, taxes, Social Security. But that's not what the Supreme Court did. The Supreme Court said, this is only an incidental burden of these individuals' religions, so there's no need to regard it as an infringement, go any further in the analysis. Of course, even to this stage, you can ask, why in Sherbert versus Werner is it enough to trigger strict scrutiny? In Bowen versus Roy, it's not an infringement at all. The court doesn't answer that question. Or continuing my look at the First Amendment, take freedom of the press. I think a tremendously important case with regard to its practical significance was Brandsburg versus Hayes in 1973. The issue was whether a reporter had to disclose sources when subpoenaed before a grand jury. And the reporters argued that if they had to disclose their sources, they'd be much less likely to talk, and without confidential sources, the public would be at a tremendous disadvantage. And the Supreme Court recognized that a core part of freedom of the press is the gathering of information. Justice Byron White, who wrote the opinion for the court, said, without protection for the gathering of information, freedom of the press would be eviscerated. But then the Supreme Court ruled against the reporters. Justice White, in his majority opinion, said, requiring reporters to disclose their sources is only an incidental burden on freedom of the press, and that therefore the law remains this day. Under the First Amendment, reporters have no right to refuse to disclose their sources. States, including California, have shield laws protecting reporters in state court, but there's none in federal court, neither a statute nor constitutional. Well, let me then get to freedom of speech, and I'll go through many examples tonight where the Supreme Court has talked about incidental burden versus direct and substantial burden is the conclusion it comes to as to whether there's an infringement. But one of the initial cases that the Supreme Court decided that used this language of incidental burden with regard to freedom of speech was United States versus O'Brien in 1968. And I've always found it a very troubling decision in terms of freedom of speech in the First Amendment. During the Vietnam War, one of the ways in which men protested was burning their draft card. David O'Brien stood on the steps of the state capitol in Boston and burned his draft card. Well, Congress, not liking this form of protest, passed a law that made it a crime for people to destroy their draft card. This seemed to me a law clearly about stopping a particular form of protest and speech. O'Brien argued this to the United States Supreme Court, and he lost. Chief Justice Earl Warren, who remembers a liberal giant, wrote the opinion for the court. And he said, this is only an incidental restriction on speech. As a result, he said, it wouldn't trigger strict scrutiny, that the government could regulate, meeting a much lesser test. Well, I hope in this brief tour of many constitutional rights, including the First Amendment, I've shown you how important the issue is of what's an infringement of speech. The second thing I then want to do is to say how the Supreme Court has often dealt with this is this analysis, or at least this conclusion, of is it an incidental burden or is it a direct and substantial burden? And again, in order to do this, I want to be concrete rather than abstract. Let me give you some examples where the Supreme Court brushed aside First Amendment speech issues by saying it's only an incidental burden, and then some cases where the Supreme Court said, oh, it's direct and substantial, therefore it's an infringement, and the government has to meet strict scrutiny. A case that's not gotten much attention was a case called Arcara Books versus Cloud. And what's involved here is an adult bookstore. And someone there got arrested for engaging in prostitution. As a result of that, the city then decided that they wanted to shut down this bookstore. The bookstore said, we're engaged in First Amendment activity. We're selling books. You can certainly punish somebody who engages in prostitution, including in our premises. But to shut down our entire bookstore, to regard it as a violation of the First Amendment. The Supreme Court said, and I quote, it's only an incidental effect on speech, therefore it's not an infringement, no need for further analysis. And then the Supreme Court applied that in a case that I find even more troubling, a case called United States versus Alexander from 1993. Ferris Alexander owned a chain of adult bookstores and movie theaters in Minnesota. He was convicted of selling 7 obscene items. For doing this, he was fined $100,000 and sentenced to 7 years in prison. The federal government, pursuant to the federal RICO law, then seized all of the contents of all of his stores. The government literally burned all of the books and the magazines that were there, and it crushed all of the videotapes. By the government's estimate, it destroyed $9 million of merchandise. Remember, only 7 of the items it found to be obscene. But the Supreme Court, in an opinion by Chief Justice William Rehnquist, ruled against Alexander. The court essentially said this was just an incidental restriction on his speech. This was punishing him for violating federal obscenity law for engaging in a RICO offense. Hard for me to think of much that's more inimical to the First Amendment than the government burning books and magazines and crushing videotapes, and yet the Supreme Court found no violation of the First Amendment. On the other hand, there are many cases where the Supreme Court comes to the opposite conclusion and says it's a direct and substantial infringement, or sometimes the Supreme Court says simply it's not an incidental burden. What I want to suggest to you is those cases have no more explanation than when the court says it is an incidental burden. Again, I'll give you a couple of examples of this. One is a case called Sorrell versus IMS. Vermont was very concerned about doctors being pressured by pharmaceutical companies to sell particular drugs. And so Vermont adopted a law that said it was impermissible to compile or sell a list that would identify what drugs a particular doctor was prescribing. I regarded this as a regulation of commercial activity. The Supreme Court, however, in an opinion by Justice Kennedy, said that this is direct and substantial burdening of speech and declared the law unconstitutional. Justice Breyer wrote a very powerful dissent arguing, no, this is just an incidental burden, and he used those words. Or take a more recent case from just a couple of years ago, and it relates to the example that I mentioned in my introduction. It was FCC Chief Brandon Carr's threat to broadcast stations a violation of the First Amendment? When is speech by government officials without any sanctions enough to be a violation of the First Amendment? It happens all the time. It might be surprising that there's only 2 Supreme Court cases about this. One was Bantam Books versus Sullivan back in 1963. There was a Rhode Island Commission on Morality and Decency, and it made a list of books that it deemed to be indecent. And a sheriff went to some local bookstores and said, you know, you're selling indecent books, and you might face criminal prosecution. No bookstore was actually prosecuted. None then was convicted. The question is, was that speech in itself an infringement? And the Supreme Court, in an opinion by Justice William Brennan, said that the threat was enough. The court used the language of prior restraints. The court used strict scrutiny and declared that unconstitutional. There's a more recent case from 2 years ago where the Supreme Court applied this. There's a case, National Rifle Association versus Vullo. Maria Vullo was a business commissioner in New York. After the Parkland, Florida school shooting, she was very upset and was angry especially at the National Rifle Association. So she went to some of the insurance companies she regulated and said, you should stop doing business with the National Rifle Association. And she said, in fact, you're violating a lot of our rules. If you keep doing business with the National Rifle Association, we might bring enforcement actions against you for not complying with New York law. No insurance company was ever subjected to any investigation, any sanctions, any prosecution. The issue was just, is the threat itself enough to be an infringement? And the Supreme Court unanimously said yes, in an opinion by Justice Sonia Sotomayor. The court relied on Bantam Books versus Sullivan. Well, I can ask you, why are the former 2 cases, Care of Books versus Cloud, the United States versus Alexander, just incidental burdens, but the latter cases I described direct and substantial burdens? And as I say, this latter issue does arise all the time. I send out a statement to the law school every fall stating our free speech policy. In part of it says that there's no First Amendment right to disrupt activities, and those who disrupt, including through their speech, will face disciplinary proceedings. After I put that out last fall, some students came to me and said, "You're chilling our speech and violating our First Amendment rights by saying that." I don't think so. And I could say to them, my letter is just an incidental burden on speech. And besides, you don't have any First Amendment right to do it. But you can certainly see how the issue comes up in so many contexts and how the Supreme Court deals with it. Well, this brings me to the third part of my remarks, which is very much the core of the paper that I'm going to write for UCLA Law Review. And that's why this distinction between incidental burdens and direct and substantial burdens is an empty one. As I said to you in my introduction, it's a conclusion that the court comes to explain the results that it wants to reach, but it's not on the basis of analysis. In fact, ask yourself, having listened to me now for a half hour, what does incidental burden mean? And the Supreme Court has never given us a definition of what's an incidental burden. Indeed, if you read the cases, you see three different ways in which the court might be using the phrase incidental burden. One thing that the court sometimes means is it's a minimal burden. And incidental just means minimal. And yet, when you look at the cases where the court uses incidental burden that way, the burden seems anything but minimal. Let me talk about a case from last June 27th, Free Speech Coalition versus Paxton, that expressly used the language of incidental burden. Texas adopted a law that said that any website with over a third of its content being sexually explicit had to do age verification. And the question is, does this violate the First Amendment? There was a prior Supreme Court case from 2 decades earlier that seemed exactly on point. In Ashcroft versus American Civil Liberties Union in 2004, the Supreme Court had declared unconstitutional the Child Online Protection Act. It required age verification for websites that had sexually explicit content. It didn't have the limit that it had to be more than a third sexually explicit, but it was certainly remarkably similar. The Supreme Court, in an opinion by Justice Kennedy, upheld a preliminary injunction that had declared the law unconstitutional. The court said, you can't restrict speech for adults so as to protect children. Age verification was a substantial burden with regard to freedom of speech, and thus the Child Online Protection Act was declared unconstitutional. But in Free Speech Coalition versus Paxton last June, the Supreme Court upheld the Texas law. Justice Clarence Thomas wrote the opinion for the court, and he said explicitly, this is just an incidental burden on speech for adults. That's a direct quote. He concluded his opinion by saying, there's no reason to believe that adults will be chilled in going onto sexually explicit websites by the requirement for age verification. What was the basis for that conclusion? I mean, to start with, there is a right to engage in anonymous speech, and the fact that adults now need to identify themselves in order to access the material is inconsistent with that. But moreover, there's good reason to believe that many adults won't go onto sexually explicit websites. If they have to produce identification, then all likelihood it's going to stay in a database. Now, so often the case you could say, this is an empirical question. Will adults be discouraged from going on to websites that are sexually explicit if they have to present identification? My intuition is that empirically we've shown there is such a burden. Perhaps I'm wrong on that, but the Supreme Court just simply concluded this is an incidental burden on speech. It mattered because by saying it was an incidental burden, Justice Thomas could say strict scrutiny isn't to be applied. Justice Kagan in her dissent said strict scrutiny was the appropriate test, and of course under strict scrutiny the government has to use the least restrictive alternative. And Justice Kagan said there's many other ways in which the state can achieve its interest in protecting children from exposure to sexual material, but since the court said only incidental burden, strict scrutiny wasn't required. I can give you many other examples where the Supreme Court uses incidental burden, meaning to minimal burden, but it's anything other than minimal burden. There's a second way in which the Supreme Court uses the phrase incidental burden. Sometimes what it means is that the government's action wasn't motivated by a desire to interfere with speech. In a case called McCullen versus Coakley that involved buffer zones around reproductive health care facilities, the Supreme Court there said that if it's government action that's not motivated by a desire to interfere with speech, it would be considered an incidental burden. There's much that I find troubling about this. If a government action is, in effect, a substantial burden on speech, why should we excuse it just because the government's motivation might have been something else? But even when you look at the incidental burden cases, this focus on motivation is troubling. Sometimes the Supreme Court says it's an incidental burden and it wasn't motivated by a desire to interfere with speech, when it's absolutely clear and obvious that's what it was all about. Let me go back to United States versus O'Brien, the case that involved the federal law that prohibited men from burning their draft cards, the case where Chief Justice Earl Warren said that this is an incidental burden. There's no doubt why Congress adopted the law that prohibited men from burning their draft cards. It was a particularly powerful way of expressing protest to the Vietnam War. It was a way that would easily create a visual image for the media. What Chief Justice Warren says at the end of his opinion is that the motive of Congress doesn't matter. We don't want the courts to be inquiring into legislative purpose. That in itself is inconsistent with so much in constitutional law. We know in equal protection, the Supreme Court has long said that if a government law is facially neutral, it can be treated as a race classification only if there's discriminatory purpose. In fact, the levels of scrutiny often require that we look at the government's purpose. For intermediate scrutiny, is there an important purpose? For strict scrutiny, is there a compelling purpose? And yet the court simply brushes aside the question of motive. Another set of cases where the Supreme Court ignores motive in deciding whether or not there's an infringement are cases that involve so-called secondary effects on speech. And again, this goes to an aspect of freedom of speech law that I find very troubling. Let me tell you about the cases, and then you can see how it seems inconsistent with the court saying, well, incidental means not motivated by desire to interfere with speech. There was an earlier Supreme Court case, Young versus American Mini Theaters. It involved a Detroit ordinance that limited the number of adult bookstores and movie theaters that could be on any city block. It was clear that this was a content-based restriction on speech. What defined whether the bookstores could be there, whether the movie theaters could be there, was very much about what was the content of what they were selling or renting. But the Supreme Court upheld the Detroit ordinance. The court said the government's goal is to deal with the secondary effects of having concentration of adult bookstores and movie theaters. There's a lot of adult bookstores and movie theaters. There's more likely to be crime and prostitution. And since the government's goal was dealing with the secondary effects, therefore it doesn't violate the First Amendment. But this was a law that was content-based on its face. It was restricting speech solely on those grounds. And yet the Supreme Court was willing to say, no, it's consistent with the First Amendment. A follow-up case was City of Renton versus Playtime Theaters. This involved a suburb of Seattle, and it adopted a zoning ordinance that required that all the adult bookstores and movie theaters be in one corner of the city, occupying less than 5% of the area of the city. Again, this was blatant content-based discrimination. It should mean strict scrutiny. And yet the Supreme Court said, well, the government's goal is dealing with secondary effects. Therefore, we don't need to worry about whether or not it's an infringement of speech. We ruled in favor of the government. Can't reconcile those cases with the Supreme Court's focus on the motive of the government. But it's not just these areas. One wonders, how much does motive really matter? There are certainly cases where the Supreme Court has found an infringement of speech without any showing that the government's motive was about limiting expression. I'll talk about a case from a few years ago. Americans for Prosperity versus Banta. Not-for-profit organizations have to file with the federal government a list of their donors. The reason for this is to help administer federal tax laws. If somebody donates to a not-for-profit, they can claim it as a deduction on their income tax. And by having not-for-profits reveal the list of their donors, the federal government can cross-check. So if somebody says on their income tax, I gave money to this organization, the organization's disclosing who gave them money would be a basis for enforcing the tax law. California adopted a rule that not-for-profit organizations operating in this state had to give to the Attorney General the same form that they gave to the federal government. Didn't require any additional disclosures, and the state said it would keep these forms confidential. The question before the Supreme Court is that disclosure an infringement of speech? Now again, this isn't the government prohibiting anybody from doing anything. It's not forbidding any speech. It's not outlawing any donation. It's just a requirement of disclosure. The Supreme Court found that this violated the First Amendment. Chief Justice Roberts wrote for the court and said that this was sufficiently likely to chill people from donating money to nonprofits that it would therefore be an infringement of speech. Justice Sotomayor wrote for the dissent and said, but there's no evidence that having the same form given to the state as to the federal government would chill anybody's behavior. Once more, the Supreme Court used the conclusion of a substantial burden, but without any evidence for it. And to, again, talk about motive, there was no indication that California's motive in this was anything with regard to speech. California's motive, like the federal motive, was just to enforce tax laws. So sometimes what the court means by incidental burden is minimal. Sometimes what the court means by incidental burden is not motivated by desire to interfere with speech. And sometimes there's a third meaning that the court gives with regard to incidental burden. Sometimes what the court says is it's a direct as opposed to an indirect burden. And there are a number of Supreme Court cases that use this language, distinguishing direct versus indirect. I mentioned to you in the context of the right to marry, Zablocki versus Red House says it's an infringement if it's a direct burdening of speech. But we know that direct versus indirect distinctions are inherently unsatisfying. It treats as binary something that's really a matter of degree. And the question is, if there's a continuum, when does it shift from being indirect to direct? You might remember that in the period between the 1890s and 1936, the Supreme Court said that Congress could regulate only under the Commerce Clause if there was a direct effect on interstate commerce. Congress couldn't regulate if it was an indirect effect. In Schechter Poultry versus United States, the Supreme Court in 1935 said that what the federal government was doing in the National Industrial Recovery Act was indirect, and therefore it was impermissible. Congress could only regulate if there's a direct effect. Well, by the 1940s, the Supreme Court overruled that distinction between direct and indirect. It hasn't been used since. I could give you other examples of areas of law where initially it was focused on is it direct or indirect, but ultimately the distinction gets eliminated because it's an impossible one to draw. And again, it's nothing but a conclusion. There's no criteria for determining what's direct or indirect. I hope that I've convinced you that the Supreme Court has failed to give guidance as to determining when is something an incidental burden as opposed to a non-incidental burden. Why does it matter? Why should we care? Well, in part, I think the failure to do this leads to inconsistency in cases. And I hope as you think about the cases that I've talked about tonight, where the court said it was incidental, where the court said it's direct and substantial, you see, there's little that separates them other than the court coming to a conclusion. I think that it's troubling because it fails to give guidance to lower courts, to legislatures, to policymakers. Imagine that you're a federal district court judge, a federal court of appeals judge, and some of the students in this room will be before too long. And you have to decide in a particular case, is this an incidental burden or is this a direct and substantial burden? How are you going to go about doing that? There's nothing in any Supreme Court decision that has given you guidance. And it matters in terms of those who are in legislatures or those who are in agencies have to decide what they can and can't do. As a lawyer, if you're working there, you can say, well, you can't do it if it's direct and substantial burden. You can do it if it's an incidental burden. But how are you going to advise them without any guidance from the Supreme Court? But maybe most of all, I think what's wrong with the failure of the Supreme Court to give us a definition of what is incidental as opposed to non-incidental is it leads to underprotection of freedom of speech. I tried to give a number of examples tonight that I find very troubling in terms of the Supreme Court's failure to protect speech. Cases like United States versus O'Brien, Brandsburg versus Hayes, in terms of the ability of reporters to keep their sources confidential. Cases like Arcara Books versus Cloud, or United States versus Alexander. And in so many of the other cases that I've talked about, where the Supreme Court didn't find protection, didn't even require that the government meet the level of scrutiny, solely by just saying it's an incidental burden. So the fourth and final part of our remarks is, what should we do about this? And I've tried to think about, if we were to replace the language of incidental burden and direct and substantial burden with a set of criteria, what would they be? And what I want to suggest to you is that we should find that there's an infringement of a constitutional right in any one of four circumstances. Now, obviously, all four of these will need to be fleshed out, and fleshed out more than I can do tonight. But at least I would suggest to you that these are four different ways in which a court should find there's an infringement, and then go on and apply the requisite level of scrutiny. First, and most obvious, is the government prohibiting the exercise of right and prescribing criminal or civil penalties for its violation. If the government is doing that, no doubt it's an infringement, and then go on with the analysis. I can't deliver the Nimmer lecture without talking about Cone versus California. Remember, this is a case where a boy in a courthouse had a jacket that had on the back the words, "Fuck the draft." The boy was held in contempt of court for this. It was said to be disturbing the peace. This was very much applying the law to impose criminal penalties. And the Supreme Court, in an eloquent opinion by Justice Harlan in 1971, found that this was an infringement and did violate the First Amendment. Justice Harlan said, to censor words is to censor ideas. We can't cleanse the English language to please the most squeamish among us. Second, if the government acts with the motive of interfering with a constitutional right, it should be deemed an infringement and then have to meet the levels of scrutiny. I believe if the government acts with the motive of interfering with freedom of speech or free exercise of religion or any other constitutional right, that should be sufficient. In this way, as I suggested to you, the court was just wrong in United States versus O'Brien in saying there shouldn't be an inquiry into motive. And I think there are instances where the Supreme Court has ignored the importance of motive. There was a case, Hill versus Colorado, and it involved the state of Colorado adopting a law to have access to reproductive health care facilities. So something that I would applaud. But what it said is you can't go up within a certain number of feet of somebody if your purpose is education, counseling, or protest. I think this was clearly motivated to interfere with speech. I also think it's a content-based restriction in speech. But the Supreme Court upheld this as constitutional. The Supreme Court said, well, the Colorado law prohibits going up to educate people about anything. It prohibits going up to people to protest about anything. So it doesn't violate the First Amendment. As much as I applaud the goal of the law, I think the court ignores that the motive was to limit speech. And when the government acts with the motive to interfere with constitutional rights, that should be sufficient. Not long ago, at the end of an opinion in City of Austin versus Reagan National Advertising, Justice Sotomayor said explicitly this. She said, if the government is acting with the motive of restricting speech on the basis of content, the government should have to meet strict scrutiny. And that's what I'm arguing for here. Motive should matter. Third, if there's more than a de minimis effect in the exercise of a constitutional right, it should be deemed an infringement. The question, of course, is what degree of burdening should be enough? And I would set the threshold very low. So long as there's more than the law would call de minimis, then it should be deemed an infringement of the right. I think this becomes particularly important in the area of free speech with regard to claims of chilling of speech. The Supreme Court has been very inconsistent as to when claims of chilling of speech are sufficient for standing or rightness, or when claims of chilling of speech are sufficient for a violation. But I think so long as there is a credible claim that speech is chilled, it should shift the burden to the government. Of course, the fact that the burden is shifted to the government doesn't mean that the government will always lose. It just means that the government's going to have to meet the requisite level of scrutiny. Now, I recognize that defining what's de minimis as opposed to non-de minimis raises many of the same questions and problems that I've talked about tonight. And it would require elaboration, including by the court over time. But I think we all have, whether it's from constitutional law or other areas of law, a sense of what we mean by de minimis. And I think it's not just about motive and purpose. If the effect is to keep people likely from being able to exercise their constitutional right, then the government should have to meet the higher level of scrutiny. And fourth and finally, if the government discriminates among people with regard to the exercise of a right, that should be deemed an infringement. The late Ken Karst, who was also distinguished professor at UCLA Law School for so many years, wrote one of those famous articles about free speech, talking about equality is a value of freedom of speech. And he was right with regard to freedom of speech, as well as with regard to other constitutional rights. And there was a time in the late 1970s and early 1980s when the Supreme Court seemed to be doing exactly what Professor Karst suggested, saying if there's discrimination with regard to the exercise of speech, that should be enough to trigger strict scrutiny. There was a case, Mosley versus Chicago Police Department, where Chicago had an ordinance that said that you couldn't have protests in your schools unless it was a labor protest related to a place of employment. And the Supreme Court analyzed that as an equal protection case because it was discriminating among people with regard to the exercise of a fundamental right. There are other cases in other areas of constitutional law where the Supreme Court has done this. With regard to the right to travel, the Supreme Court is focused on, is this discriminating people in a way that burdens the right to travel? There was a 1970 Supreme Court case, Shapiro versus Thompson. Pennsylvania had a law that said that a person could get welfare benefits to the state only if they lived there a year. And the Supreme Court said, this is discriminating among people in Pennsylvania, and it's a way that burdens the right to travel. The court, under equal protection, used strict scrutiny and found this unconstitutional. Again, I readily admit that these four criteria will all need to be developed. But I'd suggest that using these is a lot better than just a conclusion. Is it an incidental burden, or is it a direct and substantial effect? Ultimately, what I've tried to say to you tonight is the tests that are formulated by the Supreme Court really matter. They matter for future Supreme Court decisions. They matter in lower courts. They matter in legislatures. They matter with regard to policymakers. And I've tried to argue tonight that one of the most basic and important questions of constitutional law is, when is a right infringed? The court has for too long failed to develop an answer to that, and that's what we should be doing now. Thank you so much.
Yeah. 30 minutes for questions.
I'm here for you.
30 minutes for questions in an MCLE code.
It always reminds me of Sesame Street. We're brought to you by the letter A.
Tonight's program is brought to you by the word amendment. If you can scan this QR code, you'll see your MCLE. It's also outside, but let's do some questions. I'll show you that in a second so we're not too distracted. Yeah.
I'll let you call on people.
Go ahead.
I'd like to ask your reaction to the current courts in the last year and a half, picking cases and making rulings without full briefing and limiting the need to set standards that you are talking about for us to use for the next case.
I am very troubled by that, and it fits with the theme that I've tried to give tonight, the importance of judicial opinions with reasoning to guide all who have to use them. And let me give a couple of examples that fit with what you said. One of these is a case from the end of June in its Department of Homeland Security versus DVD. The Trump administration engaged in the practice, and still is, of deporting people to countries where they had no prior contacts. And this especially involved individuals from Venezuela and Cuba who were being taken to South Sudan. A federal judge in Boston found that this violated federal law. Federal law specifies where a person can be deported to: the country they came from, the country where they're a citizen, the country where they're born. There's actually 6 different categories. And the Trump administration wasn't following this. And the judge went further and said that these individuals could face torture or murder if they were taken to South Sudan. He issued a preliminary injunction. The United States Court of Appeals for the First Circuit upheld it, didn't stay the preliminary injunction, and it went to the Supreme Court. And the Supreme Court, 6-3, stayed the preliminary injunction, reversed the district court, and there wasn't a word of explanation. There was no opinion. It fits with what you're saying. I'll give another example, a case called Nome versus Perdomo that came down on Monday, September 8th. Federal judge here in Los Angeles, Judge Frimpong in the Central District of California, found that ICE agents were routinely stopping individuals without reasonable suspicion, let alone probable cause. And the Supreme Court has long said that the Fourth Amendment to the Constitution requires that before law enforcement, local, state, or federal, can stop anybody, there has to be at least reasonable suspicion that the person has committed or will commit a crime. She said that ICE agents were using 4 factors, none of which individually or collectively added up to reasonable suspicion. One was the person's apparent race or ethnicity. The second is the language they spoke and whether they had an accent. The third is the kind of job they worked, like if they were working as a farm worker in a car wash. And fourth, where they were found, like in front of a home improvement store where day laborers gather. And she said, these don't, individually or collectively, add up to reasonable suspicion. The government is prohibited from using these as a basis for stops. The United States went to the Ninth Circuit for emergency stay of the preliminary injunction. The Ninth Circuit on a Monday held oral arguments, and on Friday upheld the judge in a 55-page opinion. It then went to the Supreme Court, sat there for about 6 weeks, and then on September 8th, the Supreme Court, 6-3, stayed the preliminary injunction, in other words, to allow ICE agents to continue to do this. There was no opinion of the court, not a word of explanation. Justice Kavanaugh wrote a concurring opinion just for himself, and that's why these are now come to be called Kavanaugh stops. And Justice Sotomayor wrote a blistering dissent. These are 2 examples that illustrate what you're talking about, and they're the antithesis of what I'm arguing for from the Supreme Court tonight. Why should we be so troubled by it? Well, it gives no guidance to the lower courts. I've had a couple of federal district court judges say to me, how do they apply this when there's no opinion of the court? Was it based on standing? Because there was a standing issue. Was it based on the Fourth Amendment? There was a Fourth Amendment issue. But it's more troubling, I think, even than that. Because I said so was not persuasive to any of us as children. It doesn't become more persuasive when it comes from the Supreme Court. And judicial opinions matter. They matter for the reasons I've talked about. They matter in terms of the parties. They matter in terms of explanation to the public. And so I find this aspect of the so-called shadow docket, which you point to, particularly troubling, and those are some examples of it.
Just to follow up on the question, I think that you, as always, brilliantly given us examples and explained why what the question was about is happening. But as someone who has studied the court and the Constitution for so many years, would you share with us your reaction to this? More than being troubled, how is it that people who have been elevated to the status of a Supreme Court Justice of the United States, how are those 6 people refusing to follow the law? What is that about? What do you think?
I don't know that I have more to say than I have already. I think your question reflects my position. Justice Barrett gave an interview in which she defended not writing opinions, saying that we're acting very quickly and that rather than have an opinion that might not be developed, better not to say anything. I very much disagree with that. I mean, the Supreme Court last year decided 56 cases with signed opinions after briefing and oral argument. They, as recently as the 1980s, were deciding over 160 cases a year. They have 4 law clerks each. They have lots of time. The matters that I've given examples of are matters of life and death and basic liberties. So I think it's so important that the justices write opinion in those cases. I do think that the criticism of the shadow docket by scholars has had some effect. The Supreme Court has taken more of the cases from the shadow docket and moved them to the merits docket for full briefing and argument. We saw that last year on the nationwide injunction case, Trump versus Casa. We saw it in the tariffs cases that the Supreme Court decided on February 20th. We saw it today, this week, with the Supreme Court taking some matters off the shadow docket in terms of the federal government revoking temporary protection status, TPS status, for Haitians, and took it and put it onto its merits docket. So my hope is that here's a place where academics and public commentators have had an effect on the court, but I hope it also has an effect in their changing the practice of ruling on such important matters without any explanation.
Shauna?
Hi.
Hi there, good to see you.
Good to see you. You and I share an opposition to Arcara, but I think for somewhat different reasons. And it leads me to ask you a little bit about the de minimis effect prong of your suggested alternative. So for me, what matters in Arcara is that it's a sex bookshop where prostitution happens, and there's a connection between the content of the bookshop and the criminal activity, which was the reason for the government's regulation. But if we pan back and just ask, does a regulation have more than a de minimis effect on expression, and we call that infringement, I worry we're going to cover too many cases. So to take an example close to Arcara, if the city of New York City says, if your business establishment has 20 violations for rat infestment and vermin, and you don't clear it up, over a year, your business can be closed. Do we think when it closes the vaping store, that's not a First Amendment issue? When it closes the bookstore next door, does that become a First Amendment issue because it is more than a de minimis effect on expression?
I think it's a terrific question and a really hard question. My answer would be yes. And my answer, because I'm a law professor, I answer a question with a question. Why should we be concerned about having too many things having to meet heightened scrutiny when there's an effect on speech? Now, I can answer that. As you know, Vince Blasey wrote an article which says, the more we expand the protection of the First Amendment, the more we're going to end up diluting speech. But I don't know a basis for that other than he says so. I think that most what you're saying is, well, the government should, I say, because it's more than a diminished effect on speech, the government should have to meet intermediate scrutiny, and because it's content neutral, it wouldn't trigger strict scrutiny. And maybe it'd be easy for the government to meet immediate scrutiny here. Stopping the rats from being in the premises and no other, it's neurally tailored to achieve it. So I think the question is, my criteria would substantially expand where you get to, say, intermediate scrutiny. But what's bad about that if it leads to more protection of speech? And the reason I came to this, a great deal of thought is, if we believe that effect should be sufficient at some point, how do we draw the line of when it is? And because I can't articulate anything other than de minimis that wouldn't get us back to exactly where we are now, I'd come to that, and I'd therefore, on your slippery slope, grant the slippery slope and say, okay, so there's more protection of speech.
And every time tax policy changes, and that means people buy fewer books or print fewer books, will that also be a constitutional trigger?
I mean, the difficulty is that an infinite variety of government actions will burden speech. What if there's a park that's been used for demonstrations and the city decides it's not going to park, it's going to build low-income housing? That has an incidental effect on speech that's more than de minimis also. I agree. But what if I change that hypothetical? And what if it's a city that's tired of the protests against the government and says, okay, we're going to deal with these protests. We're going to pave over that park and we're going to do something else with it. Are you more troubled in that instance? So I readily agree that the de minimis standard has the problem you identified. And then I ask the question, and if we're going to focus on effects, where would you draw the line?
Blake?
Thanks. Yes, so just to follow up on the de minimis question, it seems like that test, as you described it, might kind of run into the same issues as the direct versus indirect. When does it go from de minimis to maximus or whatever?
Absolutely.
And so I wonder whether, I mean, just as I teach 1L torts, it led me to think about proximate cause and the alternative to a directness test that we always talk about, which is foreseeability, and which might be more tractable to say that instead of de minimis is there a foreseeable, not just intentional, but a foreseeable burden on the constitutional right, and then you could ask, would the reasonable person understand it to burden the right? Do you think that might? I wonder what you think about that alternative.
I like it. I don't know that it will get us any place different than de minimis, which isn't an argument against it. Let me go to the prior example. If you shut down the bookstore because there was prostitution there, there's a foreseeable effect on speech. If you shut down the bookstore because it has rat violations, there's a foreseeable effect on speech. Is it different than de minimis? Are there instances where one is different from the other? I don't disagree, and I think foreseeable effects is a test that I would be very comfortable with. I came to de minimis because I was trying to avoid as much as I could drawing a line on the continuum, because I have the sense that there is an intuition of when something is so trivial as to be de minimis. But I'd be very comfortable with foreseeability as an alternative test.
In the back, and then John.
Oh, hi. Your reflection on O'Brien, as well as appreciation for Justice Harlan's way with words, brought to mind another bit of language from the O'Brien decision, specifically from Harlan's concurrence, the notion of ample alternative channels of communication. I was wondering, does that notion speak to the incidental burden question? Does it provide any kind of foothold for a test? Are they just ships passing in the night?
I am very troubled by saying we can restrict somebody's speech because we believe there's another way that they communicate the message that's just effective. Let's take O'Brien. There is something particularly visually powerful about watching somebody burn their draft card. I don't know that we can have another way of conveying something that's as visually powerful as that. Let me go back to Cohn versus California. Think the words, fuck the draft. Imagine that he was to have some other words on the jacket. And actually understand it was actually a girlfriend who he spent the night with who wrote those words on the back of his jacket. But that's a different story. Just focus on the words, fuck the draft. what other three words will so powerfully convey the message as those three words? Fornicate the draft? I mean, it doesn't work that way. The reason that I think is a direct answer to your question is we wouldn't say in Cohen versus California, he can be punished for these words because there's other ways that he can express the message. It's very troubling to me to say, we're going to keep you from being able to speak the way you want because, well, there's another way you could do that. Now, there is a place in First Amendment law where this comes up, and that's when the government's engaged in time, place, and manner restrictions. The test says it has to be content neutral, it has to serve an important purpose, and it has to lead to adequate alternative places for communication. But I think what you'd be suggesting, or Justice Harlan was suggesting, would be much broader than that. And I don't want the court to say, well, we think there's another way that this could be expressed, because often there's not another way that's as powerful. I think one of the things about transgressive language, like Cohen versus California, is how very powerful it is, and uniquely powerful. And the same thing, I think, with burning the draft card.
If John was next.
Thank you, Erwin. So I'm wondering whether in your reconceptualization of this, I kind of have a feeling in your responses to some of the other folks that it's maybe sensibly, but kind of doctrinally focused in a way that doesn't quite take account of the, what some might call tension, or maybe the enforcement in some circumstances, of free speech law and free speech culture. And I wonder sometimes whether the way the court distinguishes among these things is intuitive, not explained, I agree, but intuitively sort of, this one seems like it's too much of an interference with free speech culture. This one is, so the rats, that sort of thing.
Right.
Or the question of whether there is or is not a reason to fear dilution if we go too broadly. And I sort of feel like those two things are part and parcel. I wish, of course, that if they were going to do that, they would do a better job of explaining in maybe greater detail, with maybe greater nuance, why it is that they fear one case rather than another. But in terms of people's attachment to the values of the First Amendment, not just in the particular case, but in the broader society, whether that approach might be a little different. I mean, one of the reasons that lots of people, I think, value the Harlan opinion in Cohen against California is because it speaks in some terms that actually do seem very free speech cultural oriented. Does that have a place in your analysis of this?
Let me divide what you're saying into two parts, because I think it's each part of the tension. One is free speech culture, and the other is this notion of, if we go too far, do we end up diluting free speech? In terms of free speech culture, I think the problem is it's about the intuition of free speech culture on the part of the justice on the Supreme Court. And if there's no elaboration, it's really nothing but their instincts. Let me take the case that I mentioned, United States versus Alexander, which to me has always been chilling, the idea that the government could burn and destroy books and magazines and videotapes without any showing that what they were destroying was obscene, because only some of the items have been. If there's anything to me that's about free speech cultures, we don't burn books in this society. And so, yet the Supreme Court's intuition was, well, this is just enforcing the RICO law, and the fact that it happens to be a bookstore is incidental. So why is free speech culture there not something the Supreme Court's willing to give weight to? And so I worry that free speech culture is just too amorphous and too much just lets these justices and their instincts do whatever they want and give the label incidental or non-incidental. I think the latter part of it is, if we provide too much protection of speech in terms of what's an infringement, then will that lead to dilution of speech? But again, as I said at the end, as you know so well, finding an infringement doesn't mean that the government loses. It just means that we should be applying the appropriate level of scrutiny. So if it's a content-neutral regulation of speech, it's intermediate scrutiny. And I think that's appropriate. And if we apply intermediate scrutiny more than rational basis, in more speech cases, I'm not convinced that that's going to lead to the dilution of speech. The government may win still, but at least it would win in a more elaborate, explained way in terms of the court say, here's the important interest, and here's why it's substantially related.
I wanted to ask you about, you sort of initially defined like 4 steps of analyzing a constitutional right, and your first step was, is there a right, and the second is it infringed? But I worry a little that there's sort of an intermediate step of the court sort of circularly defines rights in a way where previous precedents have said a right isn't infringed, therefore the right doesn't exist. And I'm thinking specifically of some of the anti-solicitation laws, like in the cases Breard and City of Schaumburg, if you're familiar with those.
I am.
Where the court sort of looked to whether or not particular burdens on soliciting were acceptable and concluded, well, because there's no right to speech in the private home of another, then of course we're not burdening the right. But obviously that's a little bit circular, right? Because the court could certainly define the right as, well, because this right is subservient to another, you don't have the right to apply it here. So I wonder that even in the presence of a more defined test for analyzing whether or not a right is implicated, if we wouldn't still run into a preliminary problem.
Absolutely. And at the end of my introduction, what I said was hopefully the point that we're saying the same thing, that there is an inherent interrelationship between the definition of the right and the question of whether there's an infringement. And that there are many instances where, though it's phrased in terms of is there an infringement, what they're really saying is there's not a right. And there's instances where they really focus on there's not a right, but it's really talking about the question of infringement. And I think the solicitation cases that you mentioned fit within that pattern, and I can give others. And yet, as I also said in my introduction, I think we can identify so many cases where it's conceded that there is a right, and then the question is there an infringement of that right? And I think those were the cases I was trying to talk about tonight. But I also accept what John and Shauna were saying, that perhaps if you take my approach, what the court will simply do is narrow the definition of the right so that it doesn't have to get to the question of what's an infringement.
And Bill, and then in the front, and then we'll wrap.
Hi, Erwin. Thank you for this. Since we're talking about the definition of a right, I was curious if you would speak to what's going on currently with respect to press access and how the right has been defined or redefined by the Trump administration, whether we're talking about the Pentagon or AP having their right to attend press conferences taken away because of the Gulf of Mexico, Gulf of America dispute.
It's a wonderful example in terms of the prior question. And the reason is that the Supreme Court has never found a First Amendment right of the press to be able to have access different than the general public. There aren't a lot of cases about First Amendment and press access. The place where the court has most found it is access to criminal trials in many criminal proceedings, the Richmond newspapers case. But it says in Richmond newspapers, the press and the public have a First Amendment right to attend criminal trials. It doesn't give priority. There's cases in terms of whether the press had access to prisons, Houchins versus KQED, Saxby versus Washington Post, where the Supreme Court rejects a right. And there's long been a debate among the justices and scholars as to whether or not freedom of the press gives the press some right of access for news gathering. Justice Potter Stewart wrote, both in law reviews and opinions, very powerfully about why there should be a First Amendment right of the press to have access. And the difficulty is that the Supreme Court hasn't done that. There are lower court cases that are better about this. And so there are lower court cases about when the government wants to bar particular reporters from having press privileges because of disliking what they say. And the lower court's finding that to be a violation of the First Amendment. And the basis for saying that the AP couldn't be denied White House access because it wouldn't say Gulf of America rather than Gulf of Mexico rely on the discrimination among the press and the equality value. But I think that the problem here is just what we were talking about, is it's the failure to define the right So you don't even really get in many of these cases to the question of whether there's an infringement of the right.
I think it was Paul, last question.
Me?
Yeah.
I don't want to push my luck, but it appears to me that there's been since the Trump administration began, a persecution, prosecution, discrimination against trans people. Now, one part of that discrimination is the new laws restricting their ability to state and declare their gender on official documents like passports and so forth. Now, is that a First Amendment violation, a constitutional right to declare your gender that is being infringed?
The State Department adopted a rule that said that a person's passport had to state their sex was identified at birth. It couldn't say gender identity. A federal district court issued a preliminary injunction against this, and the district court wrote a quite detailed opinion that, among other things, said, this makes no sense. You want the passport to reflect the person's gender identity at the time they're presenting themselves, because you want to see if the person is the one who's presenting the passport. Also, the district court said that in many countries this could lead to violence against individuals because of the prejudice against transgender individuals. The Court of Appeals upheld the preliminary injunction, and the Supreme Court 6-3 reversed. I think that this is certainly restricting the speech on the official document. The difficulty there is the passport your speech, or is the passport government speech? There is a Supreme Court case that said, for example, license plates, which are a form of identification, are government speech, not individual speech, and not a forum for speech. So I worry, that's a case called Walker versus Texas Sons of Confederate Veterans. So I worry based on that. But the larger point you make is true. One of the first things that President Trump did was bar transgender individuals from serving in the military. The federal district court issued a preliminary injunction, the Court of Appeals upheld it, and the Supreme Court 6-3 reversed. There was United States versus Scrimetti from June 18th of last year, where the court upheld the Tennessee law that prohibited gender-affirming care for transgender youth. There's the settlements that the Trump administration is imposing on universities to try to require that they not provide gender-affirming care. The Trump administration is trying to put into the SAVE Act a provision that would prohibit surgical procedures for transgender individuals and prohibit transgender athletes from competing in sports. So you put all of this together, it's very much what you described. How much of it is about free speech, I'm not sure, but it certainly to me raises very, very difficult equal protection issues. In our society, if there's a discrete and insular minority, at this point, certainly transgender individuals should meet that criteria.
One more round of applause. We have a wonderful reception outside where I encourage everybody who didn't get a chance to ask a question to talk to Dean Chemerinsky or talk to each other. So that's directly outside. Here's your MCLE attendance code. Again, the code word is amendment for the form. So fill that in. And then can I just get a show of hands of the students in the room? I like, oh, great showing. Okay. Yay, thank you. We have a special office hour with Dean Chemerinsky tomorrow from 11 to 12. You've gotten a lot of emails about this, but I just want to remind you. It'll be in room 2462, which is in the Dean's Suite. Come ask any questions, tell your friends who missed out, watch the recording we post, come ask questions, and meet Dean Chemerinsky in person. So everybody outside for the reception, enjoy yourselves. It's daylight savings.